Ladies and gentlemen, good evening and welcome to the Western Cape Teachers Forum, a platform where we educate to empower so that we can excel through the dialogue and the knowledge and skills that we acquire. Now, I hope everybody has had a fantastic week thus far. It's Thursday, it's almost Friday, the end of the week, and I'm sure a lot of people are feeling the heat, as it were. Now, thank you for joining us and for always supporting the platform tonight. Now, tonight we are talking to a, a stalwart in the education labor relations field, Mr. Riedwaan Ahmed. He is from the NAPTOSA Teachers Union, and he will be talking to us about the issue of progressive discipline in the workplace, but more particularly to Western Cape Education Department employees. Mr. Riedwaan Ahmed is on the program, and I'm hoping that at some point he's going to. There we go. There he is. He's on. His mic is unmuted. Mr. Ahmed, good evening to you.
Good evening, Lee, and good evening to all your viewers. It's good to be on the program this evening.
Well, thanks for gracing us with your presence. I know that you. I know that you press for time because you are hosting a radio program also very shortly in the next hour. So we're going to do as much as we can in this time. But if there's anything that our people want to expand a little bit more upon, we can always do a follow-up session. So Mr. Ahmed, just very quickly for the benefit of those who are first-time educators or new entrants to the system, your organization that you work for, NAPTOSA, what role do they play in the educational space? Just very briefly.
Lee, thanks very much for that. Obviously, as you said, I'm from NAPTOSA, that is the National Professional Teachers Organization of South Africa, and we're a trade union by its nature. And so we, for example, as a trade union, represent the interest of our members within the educational arena, and we offer professional development amongst others. We look at conditions of service. We also represent our members, for example, in arbitration proceedings and your disciplinary inquiries. So it's a bit of an all-rounder when it comes to trade unionism. I think the one key thing also from a national perspective really is the issue around salary negotiations, which is, a bit of a tamaleki, stealing our CEO's words at this stage. But that in a nutshell is what the organization is all about.
Yeah, and I think one of the things also that you guys aim to do is to build capacity in the form of information sessions, workshops, and the like. And this is one such example of where NAPTOSA is able to provide a service to not only the members but to the education sector workers at large. So thank you very much once again for gracing us with your presence and for imparting some of the knowledge that you've acquired over the time. Now tonight's topic, and I'm going to put the slide on the screen, is around the issue of progressive discipline. And if I can just get there we are. All right, so that is where we are. And I'm going to, for the sake of time, I'm going to ask you to shoot right into the content here and take it away. And at some stage, after the 7th or so slide, we're going to just pause and ask and look for if there are any questions coming through on our live feed for our people to engage on. All right.
Yes, no, thank you very much for that, Lee. I mean, we obviously appreciate the engagement from your listeners and your participants. So obviously the purpose of discipline is to correct behavior. If one looks at any piece of legislation with regards to discipline, they will tell you that the purpose is to correct behavior. And one almost kind of looks at, you've mentioned progressive discipline. If one looks at the Labor Relations Act in terms of Schedule 8, if I'm correct, which refers to the Code of Good Practice, it says any disciplinary action by an employer should be progressive in nature as opposed to being punitive. And I think that is where this whole notion of progressive discipline, found its space within the discipline arena. So we'll be looking at, for example, appropriate sanctions. We'll be looking at what would be the difference between your serious and your less serious misconduct. We will be referring to, at some stage, to the Employment of Educators Act, as well as the Public Service Act or the Public Service Regulations, because we will be focusing on, we'll be moving between educators and your public service, keeping in mind that we also have school governing body employees. However, these provisions do not necessarily apply to them unless it is specifically captured in the disciplinary code and procedure of the relevant school governing body. Then we'll be looking at the functions and the roles, of the various role players, who should be there and who should not be there, etc. And what is the procedure that is outlined when one deals with progressive discipline. If you want to know a bit more and you been a bookworm, read up, you can go to Schedule 2, Item 4 of the Employment of Educators Act, and one will then see where also it really outlines the procedure for progressive discipline. And then we'll be looking at sanctions, and here and there, obviously, I'll move between progressive discipline as well as the formal disciplinary hearing to show where the differences are, if that's okay, and possibly some examples, Lee.
100%. All right, so we're moving on to...
Pause and then also say to our listeners before the questions comes through, that I disclaim that I don't necessarily have all the answers. I don't know everything, but I will certainly try. And then some of us, who are at my age, Lee, unlike you, will remember there was a place called Joshua Door. And Joshua Door saying at the time was, a promise we make is a promise we keep. And so I will move from that premise that where I don't know the answer, I will then commit to get back to you and give you the appropriate answer. So let's get right into it, Mr. Hoffmann.
All right. So as regards the processor, you can go ahead.
Okay. So I think you've taken from the, for example, if there's misconduct, which we said, the purpose of it is to correct behavior, which means that you did something wrong. Now, when one speaks about that, we say normally late coming is a challenge at schools, keeping up with the curriculum. If one looks at Section 18 of the Employment of Educators Act, for example, you'll see under 18O, it says that an educator may not, without authorization, sleep on duty. And so that's one of the funny things which came about with regards to the Ed Laws Amendment Act early around 2000, but it is a reality out there. And so what the Department of Education is saying is that not for every misconduct, it necessitates a disciplinary inquiry or a formal disciplinary hearing. There are instances where discipline can be managed at school level, for example. And so the head of education then delegates the authority to progressively discipline employees within a schooling environment to the head of the institution. And I think that's a very important thing. So only the principal then, in fact, can institute and manage progressive discipline. It cannot be the deputy or the HODs. Well, in some instances, it could be the deputy, provided, for example, where the principal is in either on sick leave and is given the necessary authorization. Yeah. But so, in essence, then, this discipline is the responsibility of the manager of the institution, or as we said, delegated by the HOD. And so now the principal makes a determination. If you just go to your next slide, I think you'll give some, there we go. This one, really gives some examples. And I think at this stage, we need to also give credit to the Western Cape Education Department, because it seems like you've used most or some of their material, which they use when they conduct their progressive discipline training. So they speak of absenteeism, as one can see, late coming, sleeping on the job, insubordination, but of a less serious nature. The smelling of alcohol, will deal with that, and then also obviously improper conduct. Then you've got serious misconduct. Now I see the ones you've used, theft, sexual molestation, and fraud. I want to at the offset say that those are your Section 17 offenses in terms of the Employment of Educators Act. If you look at assault or corporal punishment, if one then looks at Section 10 of the South African Schools Act, it says that I think that corporal punishment has been abolished. And so they no longer refer to it as corporal punishment. It is now actually defined as being assault. And that would be your Section 18 offenses, Lee. And so those offenses are normally dealt with by labor relations, or what we call the DER,
Directorate Employee Relations.
Yeah. But the ones on my left now, the less serious misconduct, those are normally managed by the manager of the institution.
Yeah.
And so if we go to the next slide very, very quickly.
I just want to ask you a question, if you don't mind.
Sure.
So I'm assuming that the ones on the left-hand side of this particular screen, your less serious misconduct, they may, they may very well become a serious misconduct if there's a repetition of, let's say, one or more of such less serious misconduct sort of issues.
Yeah, no, for sure. Let's say, for example, we take late coming or absenteeism as an example, and we'll get to the type of sanctions that can be imposed. And obviously, if one is issued, for example, with a verbal warning, it's valid for a period of 6 months. And what the law then says that within that 6 month period, if there is as you point out, a repetition of the absenteeism, which means then effectively that the process of progressive discipline, meaning to try and assist the employee, that has failed. And so therefore that could then at some stage become, as you correctly point out, serious misconduct, which is then required for the department to follow formal disciplinary inquiry.
All right, perfect. I'll move on to the next one.
Now I think is that the next one?
Yeah.
Okay, right. So what normally happens is, so let's say an educator, for example, let's use absenteeism or late coming as your typical example for these, or like I said, not keeping up with the curriculum, etc. The most important thing is that the law says that you must apply the audi alteram partem principle. Now, in terms of the audi alteram partem principle, it says normally just to hear the other side. And so in order for that, I remember back in the day when I was a teacher at Woodlands Primary School, you know, the principal would stand at the gate, man, or at the office. And so when you're coming in late, he would tap you on the shoulder and, you know, just nudge you and say, hey, meneer, no nie môre weer nie, né? And so it was, but those days are really gone by its very nature. And so what they're saying is, once a principal has attempted to informally counsel you, by that I'm saying, you know, tapping on the shoulder.
Yes.
The law then says that there are requirements. One is that the notice must be in writing, which means the person must be informed in writing of what the allegation is. For example, it must be clear. On the 13th of May, you arrived or you reported for duty late, or on the 13th of May, you failed to inform the school that you were not going to be present on the day. And so that must be very clearly stipulated in the notice.
Yeah.
Obviously, the notice must also indicate the date, the time, and the venue. Then the notice will further say, indicate your right to representation. Now, I want to say also at this stage, you also have the option of observing a process, but for now, let's stick with the issue around representation. Then there's the issue of must sign or note acceptance. I like the word that you've used there, acceptance there, because our employees, when they get this notice, our members, for example, or employees in WCD, they think that when they sign this notice, that it is an admission of guilt. We want to make it clear that it is not an admission of guilt. It is simply that you are signing to note your acceptance that you have received the notice.
Yeah.
One of the other questions people normally ask is, you know, isn't there a 5-day requirement that I must be given from when you issue me with a notice?
That's right.
Now, there are time frames applicable in terms of the Act, but those apply to your formal disciplinary inquiries. When one speaks of progressive discipline, the law simply says, you know, that it must be reasonable. And so then if one looks at judgments or common law, you'll find that the law almost kind of says reasonable could be between 48 hours or 3 days or those kind of things.
All right.
And so, but there's no specified time. So I'm not too sure if you want me to clarify anything on that.
Yeah, I just maybe want to chirp in here with your permission. I mean, so just the last bullet there, must sign or note acceptance. Now, I know you've clarified the issue that it's not your admission of guilt, but can that potentially count against you the fact that you don't want to sign the invitation or the notice to the disciplinary meeting?
Well, I mean, look, it's my right, and I can exercise my right not to sign, but remember that with any right, there is a limitation. It's very much like the Constitution. Any right that one exercises, there are limitations on those rights. And so what the disciplinary process says, if I refuse to sign, the principal then calls his or her HOD or deputy principal as a witness to come along, issue me with a notice again. If I refuse to sign, the witness, the deputy or the HOD then signs to say, I confirm that the notice was handed to Mr. Ahmed, but he refused to sign, and then that person signs.
Yeah. Okay. And this is just one to throw in there because I've heard it some time ago. It's not a very common one, but that issue on the right of to representation. I know a lot of our people, our colleagues are members of, Legal Wise and clientele legal and for all kinds of legal services that we make use of or on a retainer, whatever the case might be. Can I say to the principal, I'm coming armed with my lawyer to the progressive disciplinary meeting because I want my rights to be defended in this proceedings?
No, I mean, yeah, thanks for that, Lee, and it's a valid and a good question. Look, unfortunately, because of the nature of this, and as we said, we go back to the Act in terms of Schedule 8, which speaks to the issue or the notion of progressive discipline. Now, progressive discipline means we're trying to help, and so we don't want to over-legalize or make this a very legalistic process. And so therefore, when they speak of the right to representation, there's a limitation and it says you have the right to be represented by either a fellow colleague, which means someone at your school, or a union representative. And so, excellent question. They don't have the right to bring along your attorney or legal counsel or anything like that in this particular process.
All right. Now, just very lastly on the slide. So I've got the right to be represented by a fellow colleague. So if I am in the employ of WCD and I teach at, let's say, Mitchells Plain Primary School, and my colleague who is very well versed in labor relations, he teaches or she teaches at Muizenberg Primary School, am I then allowed a representation by a fellow colleague who's in this employer rather of the same employer, but in a different location, as it were?
Well, it's almost kind of a bit arbitrary in my view, but again, the issue is if one looks at employment equity, they say that the workplace is not the institution. The workplace effectively is Western Cape Education Department. And so if I'm teaching at Muizenberg and I've got a colleague, someone who's teaching at Spine Road or whatever, that person certainly is my colleague. And so therefore the person would have the right to represent me. The only thing obviously is that in terms of time, that person would need to request time off from the school, and then it would not be classified as union time off for union activities. And so that could be the other challenge, if you understand what I'm trying to say. Whereas if the person is at my school,
yeah,
that process almost kind of falls away.
Okay, on to the next slide. Thank you. I'm covered with that one. Thank you.
Sure. Okay, so then we look at the background to progressive discipline. As we said, we find it in terms of Schedule 2, more specifically, it should say Schedule 2, Item 4 of the Employment of Educators Act. We've covered the fact that discipline is a management function. I need to also say that discipline can only happen within an employment context, which means the person must be in employment, the existence of an employment relationship. And so the HOD then, who is responsible for discipline, delegates this authority to progressively discipline the heads of institution, which is what we've covered. We've said that the purpose is to correct behavior of employees regarding less serious transgressions within the workplace. And the process, totally correct, it must be prompt, it must be fair, it must be just and consistent. So for example, if I came late in May, or I was absent without authorization in May, the principal can't come in June, July, August, September, and now want to progressively discipline me for something that happened 2 months or so ago. You understand what I'm saying?
Yeah.
And then also what we find really is the issue around consistency. So we find the challenge sometimes where the principal admonishes or wants to progressively discipline Riedwaan, but when Lee comes late, or Lee is absent without authorization, or for whatever given reason in terms of the serious misconduct, the principal almost kind of looks the other way. And so that is why the law speaks about, or this process says consistent, but the term used in law is contemporaneous consistency. And so that is also very, very important.
Yes, like I don't even know how to spell that word. Yeah, just very okay. So Riedwaan, so let's say I'm the principal at the school where you teach, right? And so you came late, or you were guilty of alleged misconduct. Let's use let's use late coming. But the principal. So that happened 2 months ago, right? The principal only became aware of it today, 2 months later than the alleged act was committed. Can I still then apply the principle of progressive discipline?
Yeah, well, I mean, if the it's really from the time that management becomes aware of the alleged misconduct. So you're totally correct. So if the principal wasn't aware that you had come late 2 months ago, which is very unlikely,
Yeah.
but for the purpose of this particular issue, we would say that the time frame starts from when management really became aware of it. One of the things I want to say very quickly, Leon, on a light note, is I always use the example, and I said earlier, under section 18.10, an educator may not without authorization sleep on duty. And so we have these staff meetings, that almost kind of goes on and on. And
Yeah.
I have over the years perfected this thing of sitting and looking at you with my eyes open. The challenge is this noise that I've got, man. If I manage to get that under control, I'll be on my way.
Yeah, all right. Okay, I'm gonna reserve my other comments for the question and answering session, which is coming up in the next 2 slides. So this is the next one, and then we'll take a question and answering break.
Okay, thanks very much for that, Lee. So obviously the role, as we said, of WCD discipline is managed by the Directorate Employee Relations, and they were previously called Directorate Labor Relations. So they differentiate between, for example, your serious disciplinary transgressions or misconduct. And as we said, that is covered in terms of Section 17 and Section 18 of the Employment of Educators Act, 76 of 1998. If you're a public servant, for example, that is covered in terms of the PSCBC resolution, that's your Public Service Coordinating Bargaining Council, resolution 1 of 2003. Now, for example, again, we might have employees who are employed by the school governing body, and we want to amplify and clarify that these do not apply to them, but they would have a disciplinary code and procedure attached as an annexure to their contract of employment. And, there would be similarities between the Employment of Educators Act, the PSCBC resolution, as well as your school's disciplinary code and procedure. Now, you've got the disciplinary hearing. So disciplinary hearing, as we said, this is the very formal inquiry where there's now an initiator who is an employer representative. There's the appointment of a presiding officer or a chairperson, and where an investigation is conducted. So what Directorate Employee Relations does is they get a complaint to say that they found some scripts that were unmarked, but the educator had filled in or completed, what do you call this, mark schedules, no?
Yes, correct.
Yeah, so you submitted your mark schedules, the kids have got a report, there the caretaker now starts cleaning out the cupboards, you moved classroom, and then they found, but here's some scripts unmarked. And so now it's like a sum sucking exercise, and so they do the investigation and they then would formally charge you with misconduct, but that would be a formal disciplinary hearing and not progressive discipline.
All right. Now at this stage, I'm going to just let me just pop back out here, Riedwaan, and then so we at this stage I want to greet everybody that is tuned in from afar. Chris Bam, there's Martha October from Charlesville. Charlesville is at there on the side of Charlesville.
Valhalla Park.
Okay, then there's Adrian Thomas from Paul. There's people from Geraldine. There's Geraldine from Thornton. Lynn Herman Johns. Hi, Lynn. There's Caroline Moodley from Deep River, and there's quite a number of people that are joining tonight. Shireen from Brackenfell. There's Denise Davis and Nazir Reinefeld. Hi, good evening to you guys. And so Ingrid Jones and Erin Lakaya also watching. Karen from Belgravia. And Warren Seegers from the DR, Directorate Employee Relations, one of the labor relations or employee relations officers there. Welcome to you, sir. Thanks for the support as always. And Mr. Klesha, he's a good friend of ours and a friend of the page. And there's a number of people. There's John Goodman, he's from Wellington. And John is asking, can you share this PowerPoint with pleasure, John? If you send us an inbox or email, we'll pop an email back to you with a presentation. Now, Riedwaan, colleagues, if there's any questions that you want to ask Riedwaan, or please feel free to pop it up in the comment feed here. I'm at this stage, I'm not able to see anything that's coming through from my side, but I maybe have two questions. One of it is the difference between a meeting and a hearing within the, so they make use of the word progressive disciplinary meeting. What are the limitations to a meeting versus a hearing, more particularly in relation to a sanction? Can a principal, for example, say, I now find you guilty of A, B, C, and D, right?
Okay.
So
Now,
it's twofold.
I'm glad you've raised that, and I apologize. I think maybe I should have touched on that earlier on, Lee, that when we speak of progressive discipline, it takes the form of a meeting. So it's a very kind of, almost formal, informal process. And so then you have a disciplinary hearing or disciplinary inquiry, which is a very, very formal process. But now with a meeting, for example, as you correctly point out, when you start off the proceedings, and I think we're going to get there, in a disciplinary hearing, they offer you a preferred charge, and then the person has to plead. So you either plead guilty or not guilty to the charge. In this progressive disciplinary process, because it takes the format of a meeting, and an educator cannot be asked to plead. How do you plead to the fact that you've come late? Or how do you plead to the fact that you have been unauthorized, you've been absent without authorization? So it's not really where a charge is put to you and you then have to plead. It's simply saying, look, this is the transgression that has been brought to our attention. What is your comment around it? So the person doesn't plead. And then also we still find some of our principles, unfortunately, that when you get a notice like this, it will say progressive disciplinary hearing, at the top of the letter. And the first thing that, that we do from the office is to indicate to the principal that, look, the nature of this thing, the purpose of it is corrective by its nature. And so therefore the word hearing should not be, part of this. So it's a progressive discipline meeting. But we'll get to sanctions in terms of also, again, Lee, as you pointed out with the meeting, the sanctions are really there to correct the behavior. Whereas if you look at the hearing, although one could arguably say it's also to correct your behavior, it has more serious implications for you in terms of sanctions, which I'm hoping we'll be able to still get to before we wrap up the program.
Yeah. So if a principal says to you, if the notice by its very nature speaks about hearing, one can then declare or assume that that notice is invalid because you shouldn't make use of such lingo in any case or terminology.
That's correct. Yeah, you shouldn't be using such terminology, to say. Because, it's really, the process is when I get a notice like that, I would put up a shield, if you understand what I'm trying to say. So I'll close myself down. Whereas again, the purpose and the spirit of what we call the spirit or the intention of the legislature at the time was to try and correct someone's behavior. This should be corrective. And so let's open and discuss this thing. There might be underlying challenges. And so that is why it's called progressive discipline, but a meeting as opposed to anything else.
Okay, my last question before we move along. So you mentioned earlier that the governing body employees, for example, their disciplinary code and procedure would be outlined typically as an annexure to their contract of employment, right? Now, as WCED employed teachers or otherwise, where would we find our employment contracts?
Well, you see, that's the thing. I mean, we can ask any educator on here this evening, for example, whether they've in fact seen the employment contract. And they would be able, or they should be saying to you, they've never seen the employment contract. Because your contract of employment as an employee of WCED, more particularly as an educator, is captured in terms of the Employment of Educators Act 76 of 1998. Because it spells out in terms of the PAM as well, which is your personnel administrative measures document. What are your conditions of service? What are you required to do? What are your salary level applicable when you enter or you get a promotion or those kind of things? And then also it has the disciplinary code, which is captured in terms of, as we said, section 17 and section 18 of the Act. I hope that answers your question.
100%. So just for everybody's edification, we do not have a contract of employment. And so your guide is two things: the Employment of Educators Act 76 of 1998, as well as the PAM document, the Personnel Administrative Measures. So please consult those things if you're uncertain about anything relating to your conditions of service and the like. Riedwaan, I'm going to move on for the sake of time. I think we're doing quite well, but I'm also sensitive to your obligation at the later stage. So I want to move along.
Appreciate that.
All right, so let us go back into.
I'm surprised that we haven't had any questions or anything.
Man, I think it's reflective of your fantastic presentation skills. So there's no there's no need for questions. Right, here we go.
Okay, so then we look at the role of the manager. And as we said, the manager, we're looking at the principal of the school, for example. At your district offices, it will be the district director. If in some directorates within WCD, that would be the head or the manager there. So the manager is accountable to manage discipline at the workplace. I think we've covered that. Ensure that correct procedures are followed according to relevant legislation and or collective agreements. Now, so I think you've added the legislation as the EEA, and the collective agreements would be applicable to public service personnel. Distinguish between the different functions of role players. So the principal, as the chairperson of these proceedings, should know what his or her role and function is within this particular meeting. Then there's obviously the educator, for ease of reference now as an example. It's an educator. So the educator will also be there. And then also, as we said, if the educator now uses representation by either a fellow colleague or a trade union, then that person will also be there. We've had instances in the past where the principal calls in his deputy principal, and then they say that the deputy principal is there to take minutes. But it almost becomes again an issue of, now there's management here and I'm the only educator and I'm being bullied. And so we don't really encourage, that principals have in their SMTs there, all sitting there and watching. And so it's not encouraged and it's not allowed in any event when one looks at who the relevant role players are when one deals particularly with progressive discipline.
All right,
and obviously, it must be prompt, fair, and consistent.
Yes, of course. And my apologies, I didn't pick up on it's only coming through now on my side. So one question is coming through here, or quite a few. I'll just entertain it for now. Courtney Dixon is asking, can a principal use Section 18 and sanctions in a progressive disciplinary meeting? That's the one question.
Okay. Can we do one by one?
All right, let's go for it.
Okay. So look, I mean, it's also a bit of a contentious issue. We have taken up very recently as NAPTOSA this issue with the Directorate Employee Relations. Because we're saying that you're carbon copying, you're saying that the person must come and see you in respect of the breach in terms of Section 18(1)(a), in that you brought the school into disrepute, for example, or 18(1)(c), or O for that matter. Now we're saying, look, I mean, why do you have that? You're formalizing this whole process similar to that of a disciplinary hearing, because some of us might have seen disciplinary hearing notices, and that notice really specifies that. So again, my view, in terms of progressive discipline, the principal should say, and there's an example in the Employment of Educators Act that says, please come and see me to discuss the following. You don't now quote in the air, from the Act, because again, that resorts under the issue of a Section 17 or the Section 18 offense. So in my view, and my response would be, from a considered opinion, it's a no-go.
All right. Leila Sunday is asking, is management allowed to use a disciplinary hearing as a threat to scare new educators?
Well, I think, that is really, I don't know. I mean, I was going to ask, what is your view, Lee, because I know that we've been attending the CCMA training as well, just very briefly. And I think a similar question came up there. And I think the commissioner made it very clear that it could be regarded as an automatically unfair dismissal if, for example, you threaten people with disciplinary action if they don't do this, that, and the other. If I were to be in such a situation, I would certainly want to talk to my union and refer the matter as a grievance to have this thing addressed and resolved. But it is certainly a no-no that managers can use discipline, in order to keep the employees in check or in line.
Yeah, and I mean, there are rights that employees can exercise as well in terms of, for example, the grievance procedure as an avenue to express your dissatisfaction as regards an act or an omission on the part of the employer. So yes, they as much as management has certain prerogatives in terms of progressive discipline, employees also has certain avenues to explore when it comes to expressing their particular issues at hand. All right, I'll take one more question and then I'll move on. Good evening. Okay, now I've covered that one. Okay, I'll pick it up again. Riedwaan, I'm going to ask, I'll continue. So the role of the trade union.
Okay, so the role of the trade union, obviously, as we said, is to obviously represent the employee or the workers in the workplace, particularly during disciplinary procedures, or they can either opt to observe these disciplinary meetings, and obviously also to offer some training. And as we said, there it's covered. The employee may also be represented by a fellow employee, or they say fellow colleague, or you can even represent yourself. So sometimes, we feel that we don't unnecessarily want to create challenges or issues, because even principals sometimes, and I'm sure that we have principals tuned in, some because they might have the necessary legislative background. So if you come with a trade union, it doesn't necessarily, I don't want to say scare them, but it doesn't, put them off. Where some principals might be new or newly appointed, and so, they tread very lightly or carefully when one says, I'm bringing my union representative. And so the person has the right to represent him or herself in order to try and reach an amicable resolve to this particular matter. Because as we said, it's a meeting procedure. And if you can indicate why there had been the transgression, if you accede to it to such, then the principal can say, look, I'm not taking any further action. I'm glad we've had this discussion, Riedwaan. If there's anything else, let's have a chat around it.
Yeah, I think.
Sorry,
Riedwaan. I think you've covered the this particular slide extensively on the previous slide. So I mean, in terms of the representation, the audio alter impartem rule, and delegation has been writing. So my apologies. I just want to expedite it a little bit because
no, it's fine. On the notion of the ID, very quickly,
yes.
There was this guy who promised his son if he matriculates that you would get him whatever he wants, man. And the boy said, "You can get me a TT." Now, some of our car enthusiasts will know when you say TT, you are referring to the Audi twin turbo.
Yes.
The dad said, no problem, I'll get you the TT, my boy. So when the boy matriculates, very much like your son got his driver's license, the dad said, here's my present, my boy, for you, what you asked for. Goes in the garage and he sees, hey, there's a car, but it's covered, man. The man thinks to himself, this is my Audi twin turbo, and he pulls off the cover, and there he sees, lo and behold, a TT by the Toyota Taz.
Hey. 1300 per year. All right. Listen, okay. Let's move along swiftly. I think you've covered this as well, but just very briefly, we can scan over the observer versus the representative.
Yeah, so the observer obviously assists the educator by discussing charges, is present at the meeting to observe, fairness. And when we say fairness, that refers to procedural fairness, if you understand what I'm saying. The observer can call for a timeout, which means they can ask for timeout, take the educator outside, have a chat and say, look, this is my view, etc. When you are a representative, you present the educator's case, meaning that you're almost kind of speaking on the educator's behalf. Okay, you've got to answer questions on behalf of the educator, may refer questions to the educator. These are obviously questions of clarity. Because remember, this is a fact-finding exercise and must be familiar with facts. Oh, there we go. So it's a fact-finding exercise. One of the key things, and I don't know, maybe our listeners can share maybe from the experiences, is we find sometimes that principals call in witnesses and those kind of things. Now, again, remember we said there's a difference between a progressive discipline meeting and a disciplinary hearing or disciplinary inquiry. Now, with disciplinary hearings, we know they call witnesses because the onus is on the employer to prove that the employee is guilty of the alleged offense or transgression. Now, in a progressive discipline meeting, there's no onus, to prove this and call witnesses, and then they pull out recordings and stuff. I've seen all sorts of funny kind of things during my tenure, as a full-time shop steward back in the day. And then even with labor relations, I worked there for 5 years. And even then with the trade union. But these are kind of the things that happens. And maybe, the listeners or the viewers could share their experiences. But, these are some of the arbitrary issues. There's no calling of witnesses and those kind of things. Okay, so the procedure, there's 9 stages of a disciplinary meeting. There's the open and the welcome, and this is done by the principal or the manager of the institution. So the principal will welcome the educator and the trade union or the fellow employee, outline the alleged misconduct. As we said, it has come to my attention, that last week, Thursday, you came a bit late to school, or that you had not informed the secretary or myself of your absence, and therefore, I would like to discuss this with you. Can you please respond? So it's not how do you plead guilty or not guilty. So it's asking for a response.
That's right.
As you point out there, the employee's response. And now the employees can come up with a thing and say, you know what, thank you, I appreciate it. I was a bit late and I wanted to inform you, but my phone died, or I don't know, for whatever given reason, whether you're speaking the truth or whether you're lying, that's entirely up to you. But the point of it is that the employee must be given an opportunity to respond. And so once the principal now hears the response, for example, now they deal with the dispute or the issues which are a fact. Did you come late? But these will only come into play when the person says, no, I can't remember that I came late. I signed the register, I was on time, or I tried to phone the secretary, but she never answered. We come up with all sorts of valuable and, what's the word I'm looking for?
Creative.
Creative. We've got these creative things. In any case, and then obviously the employee can state his or her case. And then the closing of initial stage is the principal will say, okay, look, thank you for your time. I've listened to what you've said. Now, also a word of caution to our principals, for example, is that I've been to a disciplinary meeting some years ago where after the employee now gave his response, the principal opened the drawer and took out the written warning, all signed and everything and dated. Now that means, that you've taken, it's a foregone, this was merely a paper exercise. You have not applied your mind. And so we're encouraging principals to say, look, allow me the opportunity to apply my mind. I'll think about what you've said and then say whether I accept your reasons or I find your reasons not acceptable.
Riedwaan, can I just pause there quickly? So whatever principal says to me in the meeting, right? Mr. Hoffmann, I've listened to what your response is, and I refute that, and I am saying to you on record that you are lying.
So now we're entering a different arena now.
Yeah.
And so obviously it's again, the principal has to manage this particular process. And the principal will have to say, look, you've got the right, obviously, to express your view. If the person goes so far as to say you're lying, you're opening yourself up to another almost kind of insubordination or whatever charge there. I would be very careful in terms of how I would address the principal. And
No,
so
sorry, what I'm saying is, so the principal is saying to the employee that, I've listened to you, I've listened to the allegation as it was expressed to me or reported to me, but I'm saying to you that you are lying, even though the principal wasn't party to the incident, for example.
Yeah, no. Okay, in that case, obviously, we would want to minute that this was the comment, and that is unacceptable. For me, if I was there, I would say, fine, look, I'll stop the meeting, I'll call a point of order and say to the principal, again, we need to look at what was the intention of this particular process. The intention wasn't to tell me I'm lying or to make me to be a liar. So it's also a human relation interaction between the employee and the principal. And I always say when I represent members, well, back in the day, I don't very much do it anymore in terms of progressive discipline, is remember, as a trade union or a representative or a fellow employee, I walk away from the situation. You remain at the school. And so this decorum must be maintained or retained. But again, if the principal says that, I would stand up, I would leave and lodge a complaint against the principal with DER to say, look, either you didn't train your people properly or whatever. So let me say then at this stage that I disclaim that the views expressed on the Western Cape Teachers Forum is not the views of the Western Cape Teachers Forum, but at this stage that of Riedwaan Ahmed.
Thank you. Thank you for doing my job. I appreciate that. All right. Okay, I'm going to move on. We've got 10 minutes left.
So if the principal now accepts the reason why you have come late, for whatever given reason, then obviously what we then say the matter rests there or the meeting is adjourned or closed. Okay?
Yeah.
If the principal, however, finds that your reason for late coming or for unauthorized absenteeism or for not keeping up with the curriculum, he finds it unacceptable, he or she finds it unacceptable, the principal then says, look, let me apply my mind, and then says, okay, I'm going to issue you with the following sanction. Now, the sanctions are limited for progressive discipline. You can do counseling, which is the first one. I can say, look here, I think you should go for counseling, or I can issue you with a verbal warning, which is valid for a period of 6 months. Okay, there we go. Let's see what you've got there. Corrective in nature, yeah, which is counseling, valid for 6 months. That is a verbal warning, a written warning, and then a final written warning. And so those warnings are valid for a period of 6 months. So if I sleep in a staff meeting, then I'll be awake for 6 months. And after the 6 months have lapsed, that warning becomes not invalid, but it's almost as disregarded. And then I can sleep again because it can't be held against me now.
Okay.
But that's on the light note. But so counseling is the first thing. So it's counseling, a verbal warning, a written warning, and then a final written warning.
Yeah.
I think the important thing we've added at the bottom there, Lee, is that an educator, oh, there you've got it. An educator may object to the sanction imposed. Now, when you object, you're simply putting some pen to paper. You are writing to say, I object to your finding, or I object to your non-acceptance of my reason, and I also then object to the final written warning or whatever you've issued me. And if you want to, you can amplify, these are my given reasons for why I am doing that. If you are a public service employee, for example, in the public service, your secretaries at the school or those employed at your district offices, that public service employee has the right to lodge an appeal, and that appeal will go to the supervisor of the decision maker. So let's take a school environment. If it's the principal, then my appeal will go to my
Circuit manager.
That is correct.
All right. Now, Riedwaan, we've got 10 minutes left, and I think we've come to the end of our. Let me just double check. Yes, we've come to the end of our presentation. So I want to just entertain a few questions, if I may. 10 minutes, and then you need to run. So colleagues, thank you very much once again for joining. There's quite a number of people on the feed, over 115 plus people joining. Thank you so much for your support. Now, Crystal is asking. Okay, before Crystal, I just want to quickly ask. So let's say I've been issued with a final written warning, right? I sign my warning, and I lodge an objection. Of what value is my written objection in response to the sanction that was imposed on me?
Okay, there's a bit of a legal issue that comes into play, Lee. For example, if one has a final written warning, now remember, if I have a final written warning, the law says, or a written warning, then the next step is, final written warning, you could be, the following one could be more serious, but it cannot be that it determines guilt. So let's say, for example, I was found guilty of late coming or non-accepted late coming, right? Now, next week, I don't come late, I come late again. Now, the principal says, yeah, but you already have a final written for late coming, so therefore you are late. You understand what I'm trying to say? It cannot be used to determine a finding, determined to say, because you did it before, you are now doing it again. Yeah. It can only be used as what we refer to as an aggravating factor. Mm-hmm. So the principal will say, okay, Lee, but you came late 2 weeks ago, for which you already have a written warning. And so now I'm going to give you a final written warning. So it becomes an aggravating factor. But talking about that, the one thing maybe that we need to look at is that they use a pyramid, almost something like this, and I apologize that I'm scribbling it, Lee. So we've got a pyramid like this. So at the top of the pyramid, you have, for example, a verbal warning. The middle one is a written warning, and the bottom one is a final written warning.
Yeah.
Okay. And people are of the belief that when I come late, for example, and it's the first time, the principal must give me a verbal warning. And for the second one, a written warning, and for the third time, a final written. It doesn't work like that. The nature of the offense will determine the entry level. Mm-hmm. And it's the prerogative of the principal or the chairperson to say, I want to give you a final written warning. So that is also another thing that I need to mention. You don't have to start off with counseling or a verbal warning, then a written warning, and then a final written warning. The nature of the offense will determine the entry level of the sanction.
You could even combine the sanctions. So let's say, for example, I'm giving you a warning in addition to a counseling sort of session with whatsoever service provider. Is that correct?
Yeah, one could also do, again, it's the prerogative
Of the
of the decision maker, which would be the principal or the manager of the institution.
All
Correct.
right. Crystal Schnell is asking or saying the following. I was issued a verbal warning, a written warning, and final written warning from my manager for an alleged misconduct that was supposed to have been dealt with. How do you go about with principals that use these meetings for retaliation against teachers? It's such a long story, but I hope this makes sense.
Yeah, I think we've touched on it briefly earlier
Yeah,
on, Lee, and that is that you have the right to lodge a grievance, because you feel aggrieved about the fact that for every little thing now the principal just disciplines me and he's singling or she's singling me out or whatever the case is. But remember, you must have substantive grounds when
yeah,
you make that decision. You can't, on assumption, say, the principal is targeting me or the principal is victimizing me. There
yeah.
must be a substantive basis and a substantive ground to what you are saying before we can refer any matter of such a nature as a grievance.
All right.
Thank
Now this one, and you've got how many minutes have you got left? You've got
you.
5. Okay, I'll make it 4. So just lastly, in terms of the sanction, I've got a view. I think I've expressed it to you before, but I just want to confirm. So the sanction that let's use the two of us as an example. So you are my principal. You imposed a written warning on me for an alleged misconduct. All right. So it's whose sanction is it? It's mine, right? It's the employee's sanction. All right. So it's 6 months, the validity period of the sanction in a progressive disciplinary context. Do I, as the employee, have the right to go to the principal and ask for my file so that I can remove my written warning which had expired?
Yeah, well, you do have the right to do that because, I mean, I remember back in the day, and we're talking early 2002, for example, when we started off with this thing, that was the actual indication. It has a validity period. And at the end of the 6 months, the warning should be removed from your file because it's now deemed to be without prejudice, and then it should be discarded. Like I said, it's not totally discarded and it's not totally without prejudice because, you see, they can use it as an aggravating factor at some stage, but they cannot use it to determine your guilt of a similar or same offense.
Yeah, and of course, if the roles were reversed, if I was the principal and you were the one that was issued with a sanction, then I would simply give your sanction to you. You can do with it as you please if the 6 month period has expired. But then what I would do is in a separate sort of a record or file, I would obviously keep my own record, and then that's
No,
for
it
my
certainly is.
yeah.
It is recorded, and I want to say even those WCD employees, and like I said, I work for them. Not for them, sorry, I work for WCD. They use a PERSAL system, and on the PERSAL system, they log all of these disciplinary processes, and so that is another thing. And so it's also even sometimes logged there, although we've WCD haven't gone to that extent, but your LROs at the district office, there's normally a form that they complete. And then they do keep a record of these progressive discipline. And hence me saying to our members normally when we represent them is, you must look at the bigger picture.
Yeah.
The idea is to try and resolve this thing at that particular level. Look at what is the nature and the spirit of the progressive discipline to correct the behavior. And, that is the way in which we would want to deal with it. Because like I said, the trade unions can come in there. We can, beat our chests. As you said, I'm a giant. But I leave. And I think that's the important thing that I really want to emphasize. If I can get a message across to those who are tuned in, and even to the broader educational fraternity, one must keep that in mind, that we are there to ensure labor peace and to build relationships. And I think that for me is very central to these. Although if I look back in my heyday, I was very aggressive as well. So I need to say that tongue in cheek.
Mr. Ahmed, we've come to the end of our input tonight. Any concluding comment that you wish to express to our friends and followers of the forum?
Look, Lee, thanks very much for the opportunity. I really appreciate it. And I hope that at least for the time that I've spent on here, that those who tuned in could at least take, one little bit of what I've said if you maybe think of a question subsequent to this, I'm sure, you know, the Western Cape Teachers Forum has a platform where they can still put those questions through. We can have a look at it. I'm more than happy. And I can then, you know, respond or reply to that. The next stage of this, obviously, you know, is the formal disciplinary hearings. There's also a collective agreement, as you very well might know, which deals specifically with sexual assault cases of learners. And there we talk of pre-dismissal arbitrations, for example. But those are very legalistic by its nature. And maybe one must see whether your members or your listeners or your, I don't know what you call your following on the Facebook page,
Friends and followers.
whether they would be interested in something like that, and we can discuss and we can do that. But from my side, everything of the best. I know it's not the easiest of times. These are trying times. But I certainly also want to commend you in terms of what you are doing. I really do appreciate it. And I like your Friday thing as well. Very
Feel Good Friday.
That's tomorrow, by the way. But so once again, to all our educators, everything of the best. You can do this, you've got this, and I want to wish each and every one of you everything of the best.
Mr. Ahmed, on that note, allow me in return to express my thanks and gratitude for your sacrifice, for sacrificing your time and your efforts to be with us tonight. I mean, every time I listen to you now, I've listened to these things over and over, but every single time there's something new that I get out of it. But that can only be effected if the sender of the message is knowledgeable and in that particular, you know, you carry with you such a, in Engels is dat, in Afrikaans is so mooi word, ek wil amper sê 'n salwing, man. You've got a fantastic man, you've got a fantastic heart, you're absolute genius when it comes to labor relations and labor law. So thank you very much for gracing us once again with your knowledge, expertise, and your presence. And I'm trusting that this won't be the last time that you will come and speak to us on these very important issues, because there's a need for that. And as you could see, the numbers are still climbing, and that speaks to the relevance of the topic. So next time when we have you on board, I'm sure that we will have even more followers. So guys, thank you very much for joining, Mr. Ahmed. Good night and all the best for your future endeavors.
Thanks very much. Pleasant evening.